Okay, I hope everybody can see the slide, the presentation that's being shared.
Yes, sir.
Okay, that's good. That's good. Uh, okay, I normally like interactive sessions, but first let's finish the operational parts as to let's cover the information that's present in the slide, and then we can have a small segment in the end of it to we can have a small segment in the end of it where we can interact and ask question doubts. I hope all of you have a book and a pen so you can make notes of things that you find that's important, or you can note down doubts that you have, which you can ask in the end. We'll start with the slides now. Okay, so today I'm actually very happy that ma'am had actually asked to speak about judgment analysis. This is because judgments are one very important judgments have a very important bearing on how a law stands as a practice, but you don't see as much emphasis on judgments in everyday practice as much as it needs to be. So before we kind of get into judgment, what judgment analysis is, how it should be done, can I have one or two volunteers who can who are ready to tell me in one or two lines in your own words as to what you understand by judgment analysis and why do you think it can be important in practice? Just one or two lines.
So people who want to respond, they should raise their hand. Okay. And one by one, I'll be taking names. Then please proceed to answer, sir. Because it is he wants it to be an interactive session so that you people learn something today. Right? So yes, please raise your hands. Okay, so I guess nobody wants to answer. Sir, you may please proceed.
Okay. Probably, we're just starting with the session, so I'll let them warm up for a while. That's not a problem. Okay, let's. Okay, I hear somebody is.
Yes. Krishnanj. Yes, Mr. Krishna.
Yes, ma'am. So, according to me, judgment is a decision given by a court. And it is important because the judgment of Supreme Court and High Courts are binding on lower courts, and so is judgment of Supreme Court binding on High Court. So on the points of law where statute does not say anything, rely on the judgment, and that's why understanding a judgment is important.
Very well articulated, Krish. That's actually a very interesting approach that I've seen, and something that I do agree with. But as the way that Krish had actually articulated the answer is the direction in which we'll be taking a presentation today. That is, Krish first went to speak about what a judgment is, and then they chose to answer as to what its importance may be. So that is the very direction we'll be choosing today, is because first we have to understand what a judgment is and what analyzing it means and why we should do it. So we're moving to the next slide. This is like a summary of what we'll be covering today. You can take this is the index. These are the main topics that we'll be touching upon today, and first we'll be talking about what a judgment is. What is the difference between a judgment, an order, and a decree? That'll be the first part. That's the most basic building bricks that we'll be talking about. Then we'll be touching upon what judgment analysis is. Then we will be talking about how it needs to be done and what are the steps in doing. And then we will talk about its application. We are learning how to mine out a mineral. Now the next step would be how can we use that mineral in usage? That is, will we put it in a machine? Will we wear it as jewelry? That's the application part. And in the end, I will give you a small recap of the whole thing, so you know what are the tips that you have to keep on mind in your fingertips that will help you in practice. Please remember that I have structured the said talk in such a way that it will help you practically. Like, of course, there is theoretical information that I've put in the that I have chosen to speak about, and that these slides do contain. But the approach that we'll be taking and the intent of me saying things the way I'm saying is so that it will help you use it practically. You may be a law student, you may be a practitioner who has just started, you might be an in-house counsel, you might be somebody who's working in a law-related roles. Any of these roles, I am trying to make the whole process as simple as possible, and I'm trying to teach you a way where you can apply it in your day-to-day situation, whichever of these roles you fit in. First, let's start with what a judgment is. What is the difference between a judgment, a decree, and an order? I hope everybody can see the slide. You guys can just raise your hands if you can see the slide. As ma'am is moderating it, I think, yeah, okay. So first we will touch upon section 33 of CPC. Section 33 of CPC gives you a combined definition, relation between a judgment and a decree. While this is not per se a definition section, it kind of summarizes what so there is this very big question, legal talk that always exists as to what a judgment is, what a decree is, what a order is, what is their relation. This causes a huge confusion to most students, most practitioners. So section 33 of CPC plays a very important role in understanding this. Let's peruse the wording of the section for now. The court, after the case has been heard, shall pronounce judgment, and on such judgment a decree shall follow. So what you understand by section 33 is, here the important words will be shall pronounce a judgment, and on such judgment a decree shall follow. Meaning, first judgment comes, and after a judgment come, a decree or order will come. Now, I still understand that it might be hard to imagine what I'm trying to say. I have prepared an analogy and visual aid for the same. We will be dealing with it at the end of the session once we have dealt with the theoretical part, and I will be explaining with example as to what these things are. So you guys don't have to worry about it. I will touch upon it. But before we get into that, first let's try and understand in words what a judgment is, what a decree is, and what an order is. Now, a judgment, section 2(9) of CPC speaks about what a judgment is. And a judgment, the definition is very simple. It basically says it is a statement given by the judge of grounds of a decree or an order. For now, let us keep the decree and order aside. Basically, what it is saying is that a judgment is a statement given by a judge in a case. That's all. Just remember this. Just note this down. Just remember this. Now it says that this judgment is of the grounds of decree or order, meaning that the judgment in 2(9) becomes the basis for your decree or order under section 2(2), which is decree, and 2(14), which is order. Okay. Now, what is a decree? A decree means the formal expression of an adjudication, which, so far as regards the court expresses it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, either preliminary or final. Now, what I want you guys to focus in here is the part formal expression of an adjudication, firstly. Secondly, what I want you to concentrate upon is conclusively determines the rights of the parties. Two important parts in this. One, it's a formal expression of adjudication. Two, conclusively determines the rights of the parties. Remember this much. Thirdly, what is an order? An order means a formal expression of any decision of a civil court, which is not a decree. So, what is the difference between a decree and an order? That's the first question that should be coming in your mind. First understand this. A judgment comes, and on the basis of a judgment, you get a decree or an order. Now, your question will be as to, okay, sir, you've told me that decree is different, order is different from the judgment. But what is the most fundamental difference that pulls them apart? Is there anybody who can give me an idea as to what or who knows, or who can in one sentence or two sentences tell me, if they know, what the difference between a decree and an order is. And please don't tell me that it is that decree is defined under section 22 of CPC and 240 order is under 214 of CPC. A very one-line simple explanation would do. Anybody?
So Riva is raising her hand. Riva, you want to say something?
Please read.
Riva, you want to answer? Okay, so Krishnansh wants to answer. Krishnansh
Please,
is saying
Krish.
something.
Please, Krish.
What I believe is decree is conclusive determination, while order is not conclusive determination by the court.
Okay, I appreciate that, Krish. I really appreciate that. Okay, I hear one more person raising there.
No, sir. That's by accident. Please carry.
Okay. I really appreciate Krish's participation. Okay. So what Krish said is true to a certain extent. That is to say, both decree and order are conclusive determinations. Whereas when a question of appeal arises, that difference comes, where appealing from an order is much more possible than from a decree. That's a very complex. What is that? It's a different subject matter altogether. So let's not get in that deep. But we'll come to a much more fundamental difference as to what part this affects. A decree deals with the substantive right. It deals with a substantive remedy, whereas an order deals with a procedural remedy or procedural right. That's why if you see one very fundamental difference that you'll see even in the definition itself is 214 itself mentions any decision of a civil court. Now, why is this wording not used in decree is what you'll have to ask. But that's a discussion for another day. But please note this down, that decree deals with the substantive part, whereas order deals with procedural parts. And you have to remember that the language of definition for order is given in an an exhaustive definition is given, where it says that any civil court decision which is not a decree. So that needs to be kept in mind. Now let's go further. If anybody has any doubts, please note them and keep them for the end, so that through that discussion, both for the benefit of the audience as well as myself, all of us will learn. Okay. So before we get into what judgment, before we get into analyzing a judgment, there are two questions that all of you will get. What is it? Like, why is this man going on and on judgment analysis? He's repeating this statement. What is it? And two, why do we need to answer this? As Krish had already mentioned that judgments are how you they fill in the gaps which legislature leaves away, right? So that is answered in the why part. And what judgment analysis is it is an exercise where we try to do an autopsy on the judgment. We break the judgment down, we pick out the operative parts, and we try to extract whatever information we can from it. Fundamentally, that is what judgment analysis means. Now the why part. As Krish had mentioned, it fills in the gaps of law. If you see, I have given 4 whys here. 1, interpretation of law. 2, quasi-legislative function. 3, understanding position of law. And 4, efficiency in legal research. 4 reasons why you should be doing judgment analysis. What our learned friend had previously answered would come in the second part. Of course, you would have heard the word quasi-judicial. This quasi-legislative is a term that I like to use personally, is because per se making legislation or legislative action is not the job of the judiciary. It is a pure job of the parliament and the legislature. But like many judgments, like S.R. Bomai and all,
Vishaka judgment.
Excuse me.
Sir, Vishaka judgment.
Yeah. 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 See, you want to contribute something? Please raise
Please
the button
raise your
first, and
hands.
then
Don't unmute yourself. Please raise your hand if you want to say something. Please don't
yes,
interrupt the session by just speaking. Okay, thank you.
yes, yes. And don't worry, you will be given an opportunity. Once you raise your hand, then I can stop. You can. Okay. Yeah. Let's continue. When we look at the judgment of SR Bomai also, or many such which kind of deals with the separations of powers between organs as well as your separation of powers between center, state, and all, from Keshwan Bharati and many such judgments, one thing is made very clear, that while separation of powers is held to be a part of the basic structure, they say that it can't be put in watertight compartments. That is to say that these powers overlap with each other. Therefore, it is more of a checks and balances system rather than separation of powers purely, as Montesquieu speaks. So that is to be remembered. Now, speaking of why you need to learn how to analyze judgments. One is interpretation of law. You have सबके पास किताब है. We have what the text says, but how is that text to be interpreted becomes a very big question, because legislature, once it is making its legislature makes the skeleton, the executive fills in the skeleton, and you have your law. But sometimes there may be situations where your law is applicable, but you do not know what to do with it. That's why you have judges. They interpret the law. Now, while the judges interpret the law, all of us know that the language of law is complex. Then how do you figure out how it should be applied? That can only be done if you sit with a judgment, you understand different parts of the judgment and analyze it. First reason. Second reason, as we already dealt with, it provides a quasi-legislative function. It fills in the gaps of law and it kind of makes law where law does not exist. And making a legislation in those parts is too much of an exercise. Two, sometimes even guidelines may be made to make law. That also judgment has done. As one of my friends was suggesting a case law, I think he was mentioning Vishaka judgment. So basically what the court had done is it had given guidelines as to making prevention of sexual harassment at workplace guidelines. And after a decade or so, getting inspired by the said judgment, the legislative action was taken for that instance. Another case law on the same line would also be Tukaram judgment. But that was different circumstances altogether. Now, thirdly, to understand what the position of law is regarding one issue. And fourthly, analyzing a judgment will increase your legal research, the efficiency of legal research. That is, you understand the law better, you will apply it better, as simple as that. Now, let us get into why we are here. We are here to analyze the judgment, learn how to analyze this judgment. So let's get straight into it. Okay, at this point, before we get into the parts of a judgment, is there anything anybody would like to add or ask of? Okay, I take that as a no for now. Okay, now we are talking about a judgment. You have two different layers. These are things that these are elements that you will find in a judgment. Layer one, the things that I've put in layer one, this is for your understanding alone. This is not a hard set concept per se. This is for your understanding. And that's why I structured it in this way. Layer one deals with what you will find in a judgment on the face of it. And therefore, you can directly use it. And layer two deals with what are the things that are mentioned in the judgment that you normally don't look at, but will help you in legal research and legal application. Let's deal with layer one first. These are things that you have to look for actively when you open a judgment. So please make sure you are noting these things down. First thing is the cause title. What is the cause title? Cause title is the name of the judgment. It can be Tukaram versus State of Maharashtra. So that is the cause title of the case, right? I have prepared a downloaded order. I have downloaded the judgment of Vinika Sharma versus Rakesh Sharma, which is a very famous judgment in the previous year. I will be explaining these elements in the light of that element once I finish these two slides. Okay, but make sure that you note down these points because it will help you whenever you are analyzing a judgment. Firstly, it is the cause title or the title of the judgment. 2, the facts of the instant judgment. 3, the legal questions involved or the issues that the court had found. 4, what is the provisions of law that were applied or decided on the said judgment. 5, your ratio decidendi or the rationale to deciding the judgment. 6, obiter dictum, and 7, decree or order, whichever one is in the said case. Your second layer is 1, the precedents that are used, meaning if the judgment has relied on previous judgments for passing the said orders, then such orders. Secondly, any analogies meaning examples given by judges. Whenever you read a statute, you have examples section, right? Even judges rely on such examples while giving orders. Some judgments may carry that and therefore they become important. 3, your citations that are mentioned in the judgment. Sometimes with precedents, older citations are given. This will help you understand the history of judicial interpretation of the said law. And finally, arguments presented by advocates on that record. I hope everybody has got different parts of the judgment as till this point. Now we'll be getting into how we can use it or how we'll be putting this into application. If somebody feels I'm going too fast, please make sure you mention the comments so I know that and I can slow down my pace, or I will continue with the same speed. Mama, okay, I don't think any. Okay. Okay, then let me continue with how we do judgment analysis. Those were the elements that, meaning I have given you all the ingredients right now. You have your carrots, you have your tomatoes, you have your peas, you have your rice to make the biryani. Now I'll be telling you how to cook it. And this slide deals with the procedure of making the said dish or how to analyze. Just remember how I structured this slide. An arrow goes down this way, and there is a subsequent section that is staying here while you do this. Imagine this diagram as we go through how to analyze the judgment. First, what you have to look at is the cause title, right? Then you look at what are the issues that were presented. Meaning, what was the issue that the said judgment dealt with? The so-and-so case deals with the co-partnership rights of women in Hindu family under Hindu Succession Act. Is Section 5 under Amendment Act 2005 retrospective or not? That is a legal question that the said judgment deals with. It might have a direct bearing on the case, but it has a much bigger purpose. That is, it can have a much bigger purpose on other cases as well as the legal situation of the country. In the country, legal situation, that is, law pe is order ka kya effect hai, these issues will have that. As well as it will have independent effect in the said case. After you see what the issues involved are, I want you guys to directly go to the order or the decree part. That is the final paragraph of the judgment. That is where you will know what happened. You will know why the dispute arose. The issue or the legal question is basically an avatar of why the dispute came. A dispute kya hai? What is the fight about? And what legal questions this fight involves. Immediately you have to go to the direct answer. The order or decree has your yes or no. If you remember the definition that we dealt with, it spoke that the decree or the order has the rights of the parties envisioned in it. The rights of the parties is put in the decree or the order. So, आपका जो question ये issue या legal question में arise हो रहा है, your order and decree will answer immediately. So your legal question is answered to that effect. What happens in the end? But this is not the end of a case law. If you restrict your case understanding to merely this, then such reading of judgment will be incomplete, because you're not taking into consideration the number of factors involved. So first, know what the legal issues are. Second, understand and read what the order or the decree says. Now, once you have read what your order or the decree says, then you always have the first 2 or 3, the initial paragraphs of a judgment are dedicated towards dealing with the independent facts in that judgment. Go and read that. Now, here, one thing that I will like to mention, and the reason why I kept facts involved separately to this side, is because while facts involved are very necessary for that case in that situation, not every legal question that is answered in the way it is answered is it is not very fact specific. It will be facts specific in the way that for that judgment it will solve the problem. But beyond this facts also you go, the said legal upholding that the judgment has will be applicable. For example, co-partnership rights. Fundamentally, it was a property dispute. But the said decision being made, the said observation being made in the case of Rakesh Sharma, Vinta Sharma was Rakesh Sharma. Nobody can argue, or in another case where it is quoted saying that no, for those specific facts that observation was there, for these facts you cannot say, unless there is a direct bearing on the observation. There, the facts involved per se will not affect your application in your case. And I hope you guys are understanding what I'm trying to say here. The application of what is held in the situation you want versus its application in the facts involved and the case of the original judgment. That is what I'm speaking about. After you deal with this triangle, you make a list of what are the provisions of law involved. Which law, which section, which subsection, which act, and its interpretation with another section that is involved of another law or the constitution. And finally, and the most operational part of the judgment that you have to learn, and this takes the most time in analyzing the judgment, is the ratio decidendi and the optare dictum part. Ratio decidendi meaning the rationale for the judgment. That is, if so-and-so order was made regarding such and such provision, in answering this legal question in these facts, why did the court do this? That your ratio decidendi will tell. That iska kya relation hai, your ratio decidendi will hold. This is the position of law in this law. This is how it should be interpreted in these facts, and therefore is question ka answer here. So your ratio decidendi is your actual reason that is given for the judgment that is given. That is the formal statement of the court. And finally, your obiter dictum. Obiter dictum are supplementary observations made by the judge while giving such a judgment, and these will not have a legal application. That is to say, आप इसको binding value के तौर पे नहीं ले सकते. You cannot take these, you cannot quote these in another case saying, my lord, so and so obiter dictum was held in the court of law, it's binding. You cannot say that. Please note difference between ratio and obiter. Ratio is the reason for judgment, whereas obiter is the observation or personal observation of the judge. So ratio decidendi is binding in nature, may be binding in nature given the hierarchy of court, whereas obiter dictum, no matter which court, which judge gives it, it is not binding in nature. It may have persuasive value, it may have academic value, but it is not binding in nature. Remember this difference, but this is how your thought process should flow when you are analyzing a judgment. That is, first read what the legal questions are involved. Legal question is directly related to your dispute. Second, what is the final solution that this gave rise to? Order decree. 3. Now, what facts were involved, and what kind of direct bearing does these facts have on the order. 4, what is the provision involved, and is there any change in interpretation towards this provision? Therefore, you will touch upon the provision of law. And finally, your ratio, decidendi, and operative dictum you will read. That is the operational part of the judgment, which will help you understand the connection between these 4 ingredients. That is, this is your rice, this is your these are your vegetables. Ratio, decidendi, and operative dictum is the gravy that will hold everything together. That's how you read a judgment. That's how you analyze a judgment. Now, while these are the main elements of a judgment, and this is how you should read it to understand what the judgment holds in legal position, how can you otherwise make use of a judgment when you're reading it? These are 4 elements in every judgment that most people ignore, that you as a law student or a lawyer needs to make note of, because it will help you. I'll tell you how it helps you. First, older precedents that are used. Now, every judgment will have a set of precedents or older judgments that it relies on. Each of these judgment will have its own observation. Ye legal question pe this and this was the holding, this and this was the holding, this and this was the holding. This will give you a history. In 1960 mein there was a judgment that held this. 1975 mein this was held. 1990 mein there was another judgment, this was held. This judgment was overruled in so and so judgment, and in this judgment, all these judgments are accepted or denied in so and so way. This will help you understand and also increase your case knowledge as to aisa hi nahi, there are other observations in these aspects also. So not only is my question A answered, but question B, C, and D that are related to question A of this legal question are also answered in the other judgments. This I will showcase with Vinita Sharma versus Rakesh Sharma. You guys just bear with me for 5 more minutes with the slides part. Secondly, go for the citations and analogy is because they directly become your legal guide as to they become your legal guide or legal roadmap. Where now so-and-so judgment I found in this judgment, and I found an older judgment which I can use for a different point of law. But where do I find? Your citation will help there. Which record, which year, which volume, and what is the page number. These things the citations will contain. And analogy, of course. Analogies are made where there will be a few points of law where neither statute will answer. And sometimes even the judge, even the bench will feel that it is not worth dealing with the said question, because that question does not have a direct bearing on this instant case. Then they'll merely give an analogy. They'll give an example, they'll give an older holding, and they'll be like, these were the things. It might have some holding of this judgment, but not a big. Then they'll give an analogy or an example. Right. And finally, make sure you also go check the arguments presented by each advocate, because when you look at some High Court or Supreme Court judgments which are recorded or which are recordable judgments, which are reportable judgments, they are normally given by legal illuminaries. They are given by senior counsels in both courts and people who are elites in the profession. So reading those observation gives you an academic interest in the way that argument is taken. Now, if you're a practicing lawyer or looking at litigation as practice, these things will help you as to making your own arguments in courts, giving your own authorities in courts. But if you are a student, then these will help you draft your moot court competition arguments, will help you give extra lines in the papers that you are giving. Because these arguments given by these advocates who are on record, they would have read hundreds of judgments, and they are trying to summarize that in 2 sentences in that order. That's why even the judge felt it necessary that no, this needs to be recorded, because the said argument has such value, such weightage. So these are elements that are normally not looked at while reading a judgment, which should be looked at is because it will help you both academically and in practice. Therefore, will definitely help you increase the value of your judgment analysis. Now, application. Now I have gone about as to what is the structure, the mechanical understanding of kya karna hai, kaise karna hai, and all this. But why should you do this? I have listed out 6 or 7 situations where this becomes actually applicable in your daily life. One, interpretation of law. You understand why a law is interpreted in a certain way and why the judge is doing so. Secondly, if you're making now tomorrow, if you're a junior lawyer engaging a senior counsel, you will have to brief them as to what your argument is. Now you will draft 30 pages, 50 pages, but you are briefing your senior counsel or your senior, or you're even explaining it to the judge. They don't have time to sit for half an hour, 1 hour, 2 hours, 3 hours and go through your document. Instead, if you analyze the judgment like this and you are able to make points, 3 lines, these are the facts. 2 lines, these are the issues. 3 words, these are the provisions. Ratio, because purpose of so-and-so act is this, so-and-so order was given. That's all. You have analyzed the judgment, you have picked out these things, you have put it in your judgment, you have quoted it to the judge. He will understand why you are using the judgment. Right. So briefing any legal brief given or making an argument in court. Or if you're framing answers, and if you're a law student, then doing this will help you answer your exams. Instead of reading a 90-page judgment and remembering the whole thing, you will remember 5 lines, you will remember the judgment, you will write it in your answer sheet, you will get out. Done. If you're giving legal opinions, if you're negotiating, in both the situations, you need to have a precise understanding of what the law is. For that, you need to know every interpretation, every application of law. That you can only learn if you read judgment and you analyze them in a way where you understand that law is living in the country. Constitution is a living document. That is only understood if you understand that it's constantly changing. Not everything changes. Parts and parts change. Therefore, you need to know what it was before and how it is changed. So the whole line of interpretation you should know, and these are places where you can apply the said judgment. And finally, giving life to a statute. Basically, as we have been dealing since the beginning, the purpose of reading judgments is because they interpret law. They give life to law that is otherwise limited to text. This is a very jurisprudential statement that gives you a difference between literal interpretation and purposive interpretation. Literal interpretation, killing somebody is murder. Purposive interpretation, killing somebody is murder, provided it is done unprovoked. Which purpose you are reading it? With the context you are reading the text. Therefore, judgment does that. A judgment tells you in what context a said law is to be read and in what context that reading is to be applied. There are 5 or 6 major rules of interpretation that will go here, which is a discussion for another day. If you guys want a session on that, you can let ma'am know and a session may be done. But for now, we will stop the application at this point.
Okay.
Now, ma'am, just one more. Before we move to the example part of it, because I want to dedicate 5 minutes where I show you the judgment and different parts of the judgment in the judgment. Before we go to that, a recap of everything that has been dealt up till this point and points that you have to remember. These I put it under 2 subheadings. Please make note of this if possible, or you can contact ma'am and the said PPT may be shared with you if that's okay with a legal reach. The questions and the points related to them. 1, 6 major elements you have to remember, and 2, 4 essential questions you have to ask yourself while analyzing the judgment. This summarizes the whole PPT. So make sure that you remember these points to remember. 6 major elements. 1, cause title. 2, facts. 3, provisions involved. 4, older judgments or precedents used. 5, ratio. And 6, order. 6 elements. Cause title, the name of the judgment. Fact, what happened. Provisions, under what law this happened. Precedents, what are the earlier interpretations. Ratio, what is the interpretation that was taken in this judgment. And order, what happened in the end. What is the conclusion? What is the plot twist? How did the movie end? 6. And finally, your essentials, 4 essentials. What happened? These are questions you should get every time you're reading a judgment. ये questions आप दिमाग में रख के you follow these 6 elements. What happened? Meaning, what was the dispute? What was decided? What is the end result? Why was it decided so? Rational. And on the basis of what authorities. Now, for example, if you, let's say you have homework to do which involves writing a story. You're writing a story and somebody asks you, why are you wasting time? What are you doing? Then you give them an explanation. Okay, no, my professor told me to write this, so I'm writing it. So there is a certain authority because of which what you says has value. So that is what, under what authorities the said reasoning was taken. So these are the 4 essential questions that you have to pose. Now I will just open the Vinita Sharma judgment. I'll be sharing that with you guys. Just 5 more minutes, and then we can conclude the session. We can move to the question answer part, and then we can conclude the session also. Just 1 second. Ma'am, I hope you can see the judgment that I'm sharing.
Yes, visible.
Okay. So everybody remembers the 6 elements, right? The 6 elements that you have to remember. So this is your cost title. Vinita Sharma versus Rakesh Sharma. Why is it important to remember this? You know what is held, but you don't know where it is held. Tomorrow, if you are quoting it to somebody and they say, "Bhai, you are just from air, you are removing the observation and tell," then you can tell them, no, in so and so judgment of the Supreme Court, so and so thing was held. So it's remember to know where this observation was made. Your cost title. Then we come to the then we come to the issues and order part of it. See, the question concerning the interpretation of Section 6 of the Hindu Succession Act 1956, so and so, has been referred to a larger bench in view of the conflicting verdicts of 2 division bench judges. This is the issue that this judgment is dealing with. Normally, because this was referred to a bigger bench and the final judgment we're looking at, only one issue is mentioned here because the reference was done for this specification. But normally, there are more than 2 or 3 issues that the court will frame, which will be quoted in the 2nd or 3rd paragraph of the judgment, or the initial paragraphs, basically. Okay, and so now you know that the question concerning the interpretation of Section 6 regarding co-cautionary rights and 2 division bench judgments having contradictory views, the issue. Now come to the order. What was held? The final part of your we understand that on this question, suits, appeals are pending before so and so. In the view of the aforesaid discussion and answer, we overrule the view to the contrary expression in Prakash versus Pulvanti and so and so. The opinion expressed in so and so is partly overruled to the extent it is contrary to this decision. Let the matter be placed before appropriate benches for merits. Now, see, so for decree, they are basically giving a decree, while the order they are leaving for appropriate benches. And the said observation is again made in earlier paragraphs, where what they have held, the co-cautionary right was upheld here. That you will find through the ratio decidendi in this, as you peruse the paragraphs where the judgments are given. But yes, and the facts of this case will always be in the initial part, which will go to the 2nd paragraph, let's say. These are arguments against separately they'll be given. where see the Amendment Act is not retrospective but retroactive in operation, since it enables the daughter to exercise their co-passionate rights on commencement of Amendment Act, even though so and so, so and so, so and so. So this was an argument given by the learned SG of India, the then SG of India. While this is not an interpretation that was accepted in the end, the said approach is very beautiful. That I'll request you guys to read the judgment itself to understand that, because we are not dealing with that, and that will take another 1.5 hours. But yes, okay. Because this, I think, because the reference, this case does not have the facts of this instant case. But yeah, and as you see, there are other precedents that they have taken up, because the issue itself mentions that it is regarding contradictory judgments in these both cases, and the ratio flows. Now, one last thing that I will want to show you guys is that this is the judgment of this case, right? Whereas the final order that was given in this case, as I have found in the Supreme Court, you can find it in the Supreme Court website. The final order looks somewhat like this. On the basis of that judgment, this order was given. Leave granted. See, it gives you a final yes or no answer. Was it granted or not? And what are the specific rights that arise from this also is mentioned here. That it is obvious that the law has now been settled in this regard to the petition obtaining so-and-so Amendment Act. In the stated decision, qua daughters born before or after the amendment in co-partnership property, it upholds it upholds their rights. In the said circumstances, this appeal is disposed of, remanding so and so. The law laid down by this court in Vindal Sharma, taking note of the facts of RFA, to necessary within 6 months, preferably within 6 months. So it is also telling what the lower courts should do. A conclusive answer is given, and the rights of the parties are very specifically mentioned. That is, within 6 months, the case needs to be disposed for the parties. Even such parts is, and when they give such a right, that will be a very depending on what the remedy is given, it will be either substantive or procedural. Therefore, it will either be a decree or an order. I'll conclude the session with this. My purpose was not to take too much time, so I try to keep it very precise. If there are any questions anybody would like to ask, or if there's something ma'am would like to add, please.
Yes, first of all, thank you so much, sir. It was such an interactive and nice session. Let's just take questions.
Yes.
So anyone who has question, please raise your hand. So Mr. Somani has a question. So yes. Krishnansh, you first, please.
Good evening, sir. My question is how to find ratio descendant in a judgment?
Yes. So the ratio decidendi in a judgment, Krishansh, when I showed you the judgment part of it. Wait, let me just share that copy. Good that you asked. Finding ratio decidendi by itself is a very huge section, but I'll try to summarize it as best as I can in the paucity of time that we do have. Where is this? Just give me 1 second. Windows. Yeah. So now, as you can see here, Krishansh, now let's. I will go to the operative parts of this judgment. Okay. So in the light of this judgment alone, while reading it, you read all the elements that I've given. But because this is a very specific question about ratio decidendi, I will be dealing with those parts because I've read this judgment already. So I'll be doing this. Now, Krishan, when you see this, they have deferred to two very specific judgments that they want to deal with here. Okay, one is the observation in Prakash versus Pulvanti, and one in Daramma and other. Basically, what Prakash versus Pulvanti had held was that Section 5 is not retrospective in nature. That is, Section 5 amendment, Section 6 amendment came by 2005 amendment in Hindu Succession Act. This case held that after it came into effect, after the amendment was made, only Section 6 in that light is applicable. Whereas what Danama had held was that it is retrospective. That is, as long as the property was not divided, even people born before and properties before the said amendment was made, it will have an effect. Now, to find the ratio of this in this judgment, be very specific, because for that you will have to peruse the judgment, the observations that were held in the said judgment, and of course, in the last three or four paragraphs will give you the connection. आपको यहाँ पे कभी मिल जाएगा यहाँ पे when the proviso of the unamended 6 came into operation, the share of the deceased co-partitionary was required to be ascertained. A deemed partition was assumed in the lifetime of the deceased. So from here on, they are holding. See, when the provision so they will give what is to be upheld and what is not to be upheld with each observation that they read. Probably this judgment is too much of a complex judgment to deal with. I'm not very sure as to how comfortable you guys are here. So where do I give you? Okay, come here. There'll be some underlying sections like this which will have crucial parts of the court took into consideration. But normally it comes just before the observation pattern. That is somewhere here, right? The severance of status, a special definition intended. The expression used in explanation 6 for partition. Wait, you can just refer. So one, be careful that you're not reading it out of, see, so basically this you're saying right here, the question raised in the said, this part is actually the ratio held in this case, Balchandra versus Poonam. In the same way, this will have its own operational part. Retrospective, retroactive, act is retrospective in nature. Red. In view of the plain language of the statute, there is no scope for a different interpretation than one suggested by text. This is a literal interpretation taken by Shyam Kumar. That is a different judgment altogether. Right. The contention of the respondent that the amendment should be read as retrospective being a piece of social legislation cannot be accepted. See, even a social legislation cannot be given retrospective effect unless so provided for or so intended by the legislature. In the present case, the legislature has expressly made the amendment applicable on and from its commencement, and only if the death of the co-partitionary in question is after the amendment. Thus, no other interpretation is possible in view of the this express language, the proviso keeping it. This is a ratio given in a said judgment, and this is the comment. This is the comment. See, if it was held, the provision is not. They will, by which option? 1 second. See here, we find that the attention of this court was not drawn to the aspect as to how a co-partitionary is created. It is not necessary to form co-partitionary to pick up. So till this part, it is obiter. We find that the attention of this court was not drawn to the aspect to how a co-partitionary is created. That is obiter. It is not necessary to form a co-partitionary or to become a co-partitionary that or the predecessor co-partitionary should be alive. Relevant is birth within degree of co-partitionary to which it extends. Survivorship is, hence we respectfully find ourselves unable to agree with the concept of living co-partitionary. This is a part of the ratio. Here ratio is divided in different parts of the judgment. This is a part of the ratio. For every judgment that you read, this will differ because this was a much bigger question of law and there were two contradictory holdings already. यहाँ पे ratio divided है आपको, so separating the ratio per se in this judgment will be a problem. बट मोस्ट जजमेंट आपका ऑर्डर पार्ट जो होगा लास्ट 1-2 पैराग्राफ उसके प्रिसाइडिंग जो पैराग्राफ्स होंगे the presiding 5 or 7 paragraphs, in that your ratio will be very clearly delineated, where they'll say that we are unable to accept with so and so view, and we are accepting so and so view because so and so law is correct. So you will normally find in the last 10 paragraphs of the judgment. But here I showed you one part of the ratio. In judgments like this, it will always be, it will be spread throughout the judgment. So it is a very judgment to judgment kind of thing. I hope that answers your
Thanks a lot,
question.
sir.
No
Yes, sir.
problem.
Yes, sir. Thanks a lot.
No problem.
There was another question from Prateek Dhole. So Prateek,
Which was the order and which was the decree? Okay, Pratik. So the one that I just presented, right? That is the judgment, because it deals with it deals with the why of the interpretation. Like वो बोलता है कि these are the facts. So and so are previous judgments. So and so is the provision of law. And considering all of this, we agree with this. We don't agree with this. So वो जो detail में था एकदम, that is the judgment. Whereas the one that I showed on the Supreme Court website, which very specifically speaks about the rights of the parties and what is to be done further, that is the order. Basically, order or a decree follows the judgment. Judgment बनता है, उसके basis पे order या decree बनता है. Understand this much. That's the flow of things. What's the relevance?
anyone else?
What is the relevance of application part? That's basically for your practical application. Like you are as I told you, judgment analysis is extracting information. It is extracting the goal that exists in a judgment. The application part speaks about how you can use it. Will you put it in? Will you use it for electricity conductivity, or will you wear it as an ornament? Both are useful applications in different situations. For law students, you will use it in exams or in a moot court situation, or while writing a paper. For practitioners, you can use it while making arguments, drafting arguments, giving legal opinions, giving drafts. See, I can't. Now if I just tell you how to do it and not tell you where you should use it, that will not gain any footation. Like you know what to do, but how can you benefit out of it? That you should know. The application part basically deals with that. I think Ravina also has a question.
Any more questions? Who wants to ask can unmute themselves and ask, please. 2 more minutes. If you have any question, let's just clarify all our doubts.
Yeah, Ravina can unmute herself. She's been raising her hands for quite a while.
No, I think Riva has some issue.
Riva, sorry. Yeah, okay.
So Krishnansh wants to ask you a question again, sir. Krishnansh,
Please.
So sorry to ask so many questions, but sir, generally I hear a statement from a lot of teachers that even obiter dicta of the Supreme Court is binding on lower courts. So is it true?
So no. Obiter dictum is not binding, no matter where it comes from. Of course, if a Supreme Court judge gives an obiter dictum, it has persuasive value. Like people look at it with respect, but it cannot be binding. It is not a like जो judgment का part है, उसके operational part में formal part नहीं है obiter dictum. Your ratio alone is formal part. Obiter dictum they will take inspiration from, but that is not binding on any lower court. So if please don't probably they only meant that obiter dictum has weightage. They would have said it in that sense. The teacher would have said it in that sense. When a Supreme Court judge is saying something, उसका वो weightage वो carry करता है. That is what it would have meant. They wouldn't have meant that it is binding, but it has weightage. Only ratio is binding, not obiter dictum. Obiter dictum is purely of persuasive value. That is, if the judge wants, they can take inspiration because it has some academic value. That's all. It may have some academic value. No problem. No. Devansh, I think, is raising hands. I think that we can take that as the last question. Devansh.
Yes, Devansh.
Sir, in the starting, you have said that the decree is basically deals with the substantial remedy and order is deals with the procedural remedy. So, can you please explain it with the help of example?
Okay. So, okay. See, so decree, when I say decree, actually, you have two kinds of, when you're talking about types of law also, or you're talking about types of remedies available. Okay, example you wanted. No, I can actually do that. I have a very good example for that. One second, one second. Okay, I'll make it simple. Let's not go into these presentations again. Very, very simply, now when you talk about a fact-based remedy and a law-based remedy. See, don't restrict yourself to this imagination. I am doing this because this will be easier to understand. This is a way to look at it. So, because this doubt was specifically asked, I'm giving you an example. Please take this as a way of looking at it. A fact-based remedy versus a law-based remedy. When I say that decree is more to do with the substantive part of it, when we looked at the order, when we looked at the order that I had shown you, it speaks very clearly stating that in view of the conflict between between the two judgment, the court had overruled one judgment, whereas partly overruled the other. That will become a decree. Right. Are you understanding what I'm trying to say?
Yes, sir. Yes, sir.
Whereas your procedural remedy will have a direct what is that? It will have a direct fact-based remedy. Instance, injunction order पता है ना आपको?
Yes, sir.
You get a stay order. You get an injunction order. Basically, stay मिलता है. You can go and execute in a court of law. Decree को execute नहीं करवा सकते. Whereas order को execute करवा सकते हैं. You can go and get an actual. You can have like. You understand the application. You can get a police. You can get an executive body to come and act upon it. You can go find an execution or proceedings against it. That's where your procedural remedy comes into question. That's why it's called a stay order. It's not called stay decree. Your right is upheld. In a decree, your right is upheld. In an order, you're given a remedy. Are you understanding the application?
Okay, sir. Okay, sir.
Is it unclear? If it's unclear, please tell me what part is and I can touch on it. Or else we can end this session.
Okay. So, thank you so much, Sai sir. Thank you so much for taking out precious time from your busy schedule. We apologize for a bit of delay because I myself was stuck in something. So, guys, please do tag legally, tag sir on LinkedIn. Based on that, you will be provided your certificates, participation certificates also. And sir, it was a wonderful session. It was so practical. I think law students, lawyers, be it an in-house counsel, be it a lawyer, be it a practicing lawyer, be it a corporate lawyer, we should know this basic stuff. We should actually have exact knowledge as to what are different parts of judgment, what part of a judgment is relevant, what part of a judgment, if we cite, will be beneficial to our client or not. We should know this, because if we don't clear this doubt right now, it will be with us throughout our legal career. And then nobody teaches, nobody spoon feeds once you step into the career. That's how things are. So, Sai sir, thank you so much, for being a part of this wonderful session, and we are so grateful